they're going to integrate some new language and some new criteria within the Indian Child Welfare Act. So we have a number of resources that have already been developed that we will need to update with this new information. So this webinar is the beginning of one of those updates. So what we're going to be looking at today is looking at a little bit of an overview of why the placement preferences are in place. Many of you who are service providers probably already have your own perception as to why they're in place, but I'm going to share with you mine. We'll look at the new ICWA guidelines and their impacts, and then also look at some of the areas in which the tribes are really going to need to be focused in what they establish, whether it's by resolution, a different order of placement preferences, or process by which they can be contacted and participate in any sort of discussion with the agencies or the courts about a child who is going to be identified as Indian, whether or not a placement is required, and which placement options are available in the community. Okay, so with that, let's get started. So when anybody asks me about why ICWA is in place, and believe me, I get that question more often than I actually like. There's a number of people who don't understand why there needs to be laws for Indians that don't exist for non-Indians. And then in the child welfare realm across the nation, I also get a lot of statements about it would be nice if every child could be treated as Indian children are with the protections of the Indian Child Welfare Act. So what we look at when we look at ICWA, we often look at the history of it. But sometimes I think it's important just to remember that it's really difficult to create law that legislates about human interaction, human feelings. But we have to remember that that's what this law is designed to protect. It's designed to protect a very unique dynamic that exists between tribal children, tribal families, tribal communities, and tribal culture, all of which play a part in developing each one of the individual components. And by that I mean there's a direct relationship, a symbiotic relationship, if you will, between the kids and the culture, between the culture and the community, and so on. So as each one grows, they enhance the other. And if we lose any aspect of that, if we lose one child in any community, it has an impact. If we lose a number of children, as you're seeing in the South Dakota issues, you really have a great impact on the culture that can sometimes take a generation to really heal or revive. So when I look at this law, I want and I hope to share with you that when you look at this law, that you're actually seeing the faces of those kids, the families that this law is designed to help, and that culture that survives so much that it can actually remain intact and progress into the future. So when I talk to people about tribal cultures, because sometimes it's difficult for people to understand, there's a tendency for the broader community to say, well, the tribal culture is what we understand it to be, which is sometimes a very superficial view of it, which might be just about regalia, might just about be song. But it really is about the interactions on a daily level with family groups and the tribal community. It's about the capacity of learning to participate in ceremonies over a lifetime, and then those ceremonies can sometimes be altered due to environmental changes, due to the lack of people who might actually be able to teach those ceremonies. And so a lot of these things are so interrelated, and it's on such a minute detail level on every day that we sometimes have a difficulty explaining it. It's not just that the child needs to come back and be part of the community once a year. The child needs to understand more than what's on the surface, what people would identify as tribal. They need to understand how the tribal government works, what those family dynamics are. And for those of us who are from the tribal communities, that's not always the easiest thing to learn. You have people who have long-term relationships over generations, and those things are all learned at that family level. So the bottom line is that participation in the activities of the tribe as a living community are really the right for that child. Sorry, Deborah, I got that message. Let's see, I'm going to turn this volume up full blast. We did a quick sound check at the beginning. Is that any better? Let me try and get this microphone as close as possible. Okay. If it stays difficult to hear me, we'll try maybe one or two more slides, and I may change back to the handset. So bear with me one or two more slides, and then let me know how it goes. Okay. So the second aspect of trying to teach people about tribal cultures is also trying to explain that a lot of tribal communities do not focus simply on the nuclear family unit, that there is a role for elders and others in the community in the life of a tribal child. And sometimes that depends on who the person is explaining it, their own interactions with their own communities, and the presence of those people in their lives. But one of the things that we can say is that across the country, tribal justice systems that are effective will often administer any sort of punitive measures or any sort of dispute resolution measures within a community structure, meaning that there's a little bit of community knowledge, there's a lot of community participation. It's not just the family. Some tribes will have a peacekeeping process that allows them to bring anybody from within the community to actually participate in the punitive measures that the person may have to deal with. And sometimes these are long-term measures. So there is a little bit of community investment and, of course, accountability for that individual. And then with all of that, we've got tribal cultures that have really faced a number of challenges, and those really are they're about the settlement and development of the United States. They face challenges such as changes in the homeland, the environmental situation, the loss of people and lands, the generational trauma that is really starting to be acknowledged more recently, and then surviving now with the modern stereotypes, the racisms, and the health issues. And there's a great deal of marginalization that goes with each one of those situations. So in some of the work that we do at NIJC, we work with young people to try and counteract these more modern-day issues, the stereotypes and the racism and the health issues, by building a strength or an internal capacity to really rebound when they're the target of those types of issues. So the focus that we work on is trying to make sure that people understand the roots of where the Indian Child Welfare Act was developed and what it's intended to actually remedy. And I'm not going to go through all of the details on the next few slides, but if you download it, you'll have all of the information. But prior to the adoption of the Indian Child Welfare Act, the Association on American Indian Affairs had done a study and reported findings that literally floored most of the congressional people that were involved in child welfare at that point. The numbers were fairly horrific. They were completely out of balance with the population of Indian children in those states. And in comparison to non-Indians, you'll see numbers like these, and this is for Minnesota, that the foster placement of Indian children was 5 times that of non-Indian children. But across the board, Indian children were making up less than 2% of the population of children that were subject to placement. So here are a few more. And like I said, I won't go through all the details and read these to you. You can download these and take a look. If you get the full report, there are rates that are reported for every state, including California. Not every state has both an adoption and a foster care rate or a comparison with non-Indian children, but there is data of some kind for every state. And what everybody needs to understand is this is not a report from the 1800s. This is a report from the late 1960s, early 1970s when they were collecting this data. And we have still a number of states that have very disproportionate rates of foster care and adoptive placement for Indian children. So in 1978, ICWA was adopted. It was passed by Congress into law. It's codified at 25 U.S.C. Section 1901. And the legislative history relied heavily on that report, the Association on American Indian Affairs. And essentially, we see a lot of statements that come from that legislative history, such as the following: the wholesale separation of Indian children from their families is perhaps the most tragic and destructive aspect of American Indian life today. And that really supports, in terms of my perception, the idea that children are a necessary component to the generational transfer of tribal culture. So when we look at that, we have a very strong act that's passed for a very specific purpose, which is to maintain a strong bond between Indian children, Indian families, and tribal communities. But what we're finding is that there's a number of loopholes and ways to get around the act, and the new set of guidelines was designed to stop that. But our original language starts off with a few key definitions that we're going to go over. And keep in mind, we're really focused on the placement preferences. So we're not going to go over every definition. We're not going to go over the entire act, but just a few that will keep us in the realm of just the placement preferences. So the first one is the definition of an Indian child, and sometimes this can be very troubling because it's got a number of components to it, and as any good lawyer will do, they dissect the language. So my first goal is you underline all the ands, the ors, the musts, the shalls, and you make sure you understand the scope of the rule. In this particular definition, Indian child is an unmarried person who is under the age of 18 and is 1 or 2. 1, a member of a federally recognized tribe, or 2, eligible for membership, but keep in mind that 2 has a second part, and that is that they're the biological child of a member of a federally recognized tribe. But note that over the years, through case law, formal enrollment in the tribe is not necessarily required. So that's one of our primary definitions. The next is the Indian child's tribe. And this has always served as a little bit of a problem for the agencies and for the courts because children can be eligible for membership in more than one tribe. Their family, who may not be enrolled just yet, may be eligible for membership in more than one tribe. And in some instances, we have tribes who do not open rolls for membership until a child may turn 18 or reach a certain age. So it becomes a little bit more difficult for a child to actually gain membership, and maybe even in some instances get a certification from a tribe that says that they are eligible for membership. And this is one of those areas that we're really going to focus on making sure that tribes have a process in place when they are contacted to be able to have someone on staff who is trained in how to do the research and come up with a quick certification as to whether the child is or is not eligible for membership in that tribe. Okay. The next definition is of extended family, and this is another one that's impacted by the new guidelines, which we'll see a little bit later. But another area as well in which the tribe has a role to play, which is to develop their own version of extended family, a definition of extended family that they can include in their own tribal codes or their rules. So in this particular instance, extended family members defined by the law or custom of the tribe, or in the absence of such law or custom, shall be a person who has reached the age of 18 and who is the Indian child's grandparent, aunt, uncle, brother, sister, brother-in-law, sister-in-law, and so on, as you can see here. Now, where we see a lot of tribes who have put this into their own terms and redefined this for their own codes has been in tribes that have very strong clan systems, in which a person who is a member of the same clan may have a stronger relationship than, say, somebody who is an in-law or even, in some cases, an aunt or an uncle. If your community has recognized relationships, and they don't necessarily have to be familial or even through a clan system, which would be more cultural, it can be based upon criteria such as having lived with somebody for a certain amount of time or having a certain role in that child's life. And you can define those. You can include those in your code. And it would be a good idea to have that in there. But you need to really make sure that that is how you want that order to occur. Once you do, the new guidelines are really going to instruct the agencies and courts to follow the tribe's extended family member definition. So just make sure you have it lined out as much as possible and as much detail as possible so that the courts can actually use it to make their decisions. Okay. Now before we start this slide, I haven't seen any more comments about the volume, so everybody can hear me okay? If not, let me know, and then we'll switch over to the handset. Okay, so far so good. Okay. So thanks, Deborah. When does ICWA apply? So we have a two-pronged test, and I'm sure that most of you know this, but it is important for us to look at this terminology because it's always our starting point. So the two-pronged test to determine when does ICWA apply is, number one, is the proceeding a child custody proceeding initiated by the county or the state? And two, is the child involved in Indian child as defined by ICWA? And that's one of the definitions that we just looked at. And the proceedings that are covered, they're foster care placements, TPR, pre-adoptive, adoptive, a status offense, and in California in particular, the 601 series. Now, proceedings that are not covered, this ICWA as a law does not apply to tribal court proceedings. Any placements that are based upon an act that is, if committed by an adult, would be deemed a criminal offense, and of course any divorce or custody proceedings between the parents of a child. That really hasn't changed, but it does give you some idea in terms of all of the laws and all of the rules that you have to look at to actually implement and apply ICWA to a case. So we start off with the federal statute that came in 1978. We have to look to the state version of ICWA, their rules and regulations, to implement it for the state courts and for the agencies at the county level. And then we also have to look at the federal guidelines and regulations, and that's where we are today. The last set of guidelines were issued in 1979, and the implementing regulations that go with that have really been advisory. But today we have a new set of guidelines that were effective as of February of this year, and proposed regulations that we'll probably get back by the end of the year. So our first step will be really to look at the guidelines because we're subject to them now. And also, just in case you haven't looked at these things in a side-by-side fashion, the guidelines are a majority of what's going to be in the regulations. So the proposed regulations are really about implementing the guidelines as a required rule and regulation that will be applicable to the state courts and to state social services and other agencies that deal with placement. So it's all very interpretive at this point. A lot of the case law that we had before has really been interpreted, if you will, with respect to the language in the guidelines. We have a lot of good things that have occurred out of this, some things that I am actually very thrilled to see. So we're going to move into the next section here. Let's take a look at the placement preferences as they stand. This is pre-guidelines. So this is just a chance for us to take a look at how they are. The language in this has not really changed as a result of the guidelines, but the interpretation of terms such as the extended family, such as good cause, those things have gotten a little bit more definition for us and a little bit more clarification. So the adoptive placements, and I'm really assuming that most people here on the call are familiar with these, but I'm going to walk through them and then we will start looking at the guidelines. In adoptive placements of an Indian child under state law, the preference shall be given in the absence of good cause to the contrary. And I always underline everything that really needs to have some interpretation or have some attention. So to a placement with, number one, a member of the child's extended family. And this definition is in the statute under 1903 and number 2 in the definition. We just looked at that definition. And remember that this is one that the tribe can set forth in its own tribal code. So as the state court and the agencies go through this process, it is really necessary for them to work with the tribe to determine if the tribe in fact has their own definition of extended family. Number 2, placement can be with other members of the Indian child's tribe, or number 3, other Indian families. Now let's go back up here, in absence of good cause to the contrary. Before the guidelines, there was not a lot of information to interpret good cause. In fact, a lot of the good cause definitions or criteria has come from the court's rulings. And across the country, we've had good cause that ranged from the child's welfare and their ability to have special needs met that would require deviation from the placement preferences as noted, all the way to a 3.5-mile drive between the tribal facilities and the state facilities being enough good cause that it would cause the family and the adoptive family harm to have to travel that far. So it was really, not really good cause. It was just a way to get around it at that point. So what's going to happen with the new guidelines is there's going to be a new requirement of documentation before there's actually a placement. So that helps clarify that large loophole a great deal. The second set of placement preferences has to do with foster care or pre-adoptive placements. And in this case, there is a lot of criteria in the first paragraph where it begins any child, and then the placement preferences are in alignment. So you really do need to pay attention to the criteria that must be met before you can actually choose a placement. So in this case, any child accepted for foster care or pre-adoptive placement shall be placed in the least restrictive setting. That's one of your first criteria, which most approximates a family and in which his special needs, if any, may be met. So we must have that in place before we can determine whether or not a placement can occur in line with the preferences below. The child shall also be placed within reasonable proximity to his or her home, taking into account any special needs of the child. In any foster care or pre-adoptive placement, a preference shall be given in the absence of good cause to the contrary to a placement with, and then here's your preference lineup, a member of the Indian child's extended family, a foster home, license approved or specified by the tribe, an Indian foster home, licensed or approved by an authorized non-Indian licensing authority, or an institution for children approved by an Indian tribe or operated by an Indian organization which has a program suitable to meet the Indian child's needs. There's a question posed by Josie, and Josie, we're going to get to that a little further down the line. The documentation will come from the agencies and the courts. So I will answer that question when we get there, probably another 4 to 5 slides. Okay, so the rest of the sections in the placement of Indian children provision in the original statute include a reference to C, the tribal resolution for a different order of preferences. And this is one of those things, I've already hit on it enough, we probably don't need to do it anymore, but it is something that every tribe needs to know, that they need to have a determination as to whether or not they want to create their own order of preferences. And that is done by a resolution process. They can just support what is in the original statute. They can add to it. They can change it altogether. Now, at the very end of this, it says, where appropriate, the preference of the Indian child or parent shall be considered, provided that where a consenting parent evidences a desire for anonymity, the court or agency shall give way to such desire in applying the preferences. So if a parent and a child, actually in the new guidelines, the child who can communicate a preference, if they do so, it should be considered. It must be considered within the criteria and within the preferences in order that they are provided in the statute, but it should be material to the decision. So D, social and cultural standards are applicable. The standards to be applied in meeting the preference requirements of this section shall be the prevailing social and cultural standards of the Indian community in which the parent or extended family resides or with which the parent or extended family member maintains social and cultural ties. Now, to me, this has always been, on its face, very understandable, but it has caused some problems in terms of loopholes to avoid the application of the placement preferences. And we have had questions, or if you will, assessment or analysis by social service agencies and state court judiciary about the existing ties between the child and the family and the tribal community. And the new guidelines are really moving away from the ability for the agencies and the state courts to make those analysis. So that's a little bit of good news. And finally, record of placement and availability. So under state law, a record of each placement of an Indian child shall be maintained by the state in which the placement was made, evidencing the efforts to comply with the order of preference specified in this section. Such records shall be made available at any time upon the request of the Secretary of the Indian Child's Tribe. And this provision under the new guidelines is going to be reinvigorated by the documentation that's required if there's a deviation from the placement preferences. And we will get to that documentation here in a little bit. Okay, so let's move now into the new guidelines. And thanks for bearing with me. So if you don't have them yet, you can get the new guidelines and the proposed regulations off the Bureau of Indian Affairs website or the NACTF.html webpage under NIJC's website. And those materials are all posted and available. And you'll notice there's a great deal of similarity between the content of the guidelines and the proposed regulations. As I said before, the guidelines were effective as of February 2015. And the proposed rules, they just closed for their comment period, I believe at the end of May. And the expectation is that we should have the proposed rules or the rule in place or the content of that rule by the end of this year, foregoing any administrative issues, hopefully. So what is it that we need to know in terms of actually applying ICWA? The guidelines, like I said, the last set were in 1979. This new set actually is going to replace the old set. It is designed to clarify terminology that has been troublesome in some of the cases, and it's designed to actually eliminate the old guidelines so that there is no confusion if we're doing a comparison. Now, guidelines themselves are not necessarily considered mandatory. However, if you look at the guideline language, it has a lot of shalls and musts and ises and requirements on the agencies and the state court. And that is, again, for the purposes of incorporating that language into the regulations that have been proposed. So don't be fooled. I've had a lot of people already come to me and say, how is it that they can require this in a guidelines? And the explanation is really, well, this is, consider it a practice time. The guidelines are in place until the rule actually takes effect, and if there's any deviation between the current guidelines, the new guidelines, and the rules, we'll know what they are when we get to the end of the year. So we may have another one of these webinars to clarify any differences between the guidelines and the adopted rule early next year. Okay, so when you look at the new guidelines, it's broken up into the following segments. Sections A through G, and the titles there you can see. Our focus is really going to be on content from Section B and Section F. And as we go through this, there's a few things from Section A that I would just like to highlight. So we'll move through. From Section A, there are subsections, and the section headers are designed as questions. So one of my favorite highlights now is A.5 or A.5. How do these guidelines interact with state laws? So this is the question that we've been hearing quite a bit from state personnel. And it says these guidelines provide minimum federal standards. And that's fairly clear on its face. Whenever you're looking at the federal statute for ICWA, you have to always remember that there's state implementing laws that support that. And in some instances, and California is definitely one of those states, where the protections are a little higher standard than what is in the federal minimum standard. So the guidelines provide a minimum federal standard and best practices, and the goal is to ensure compliance with ICWA. But in any child custody proceeding where the applicable state or federal law provides a higher standard of protection to the rights of the parent or Indian custodian, then the protection accorded under the Act, ICWA requires that the state court must apply the higher standard. So every state has a chance to create a higher standard, which then is required to be applied. Lower standards must all meet the federal minimum standard, which is set forth in the statute. And the statute, of course, has got some open areas. The definitions needed to be clarified, and that's what these guidelines are for, to try and close some of those gaps. And then we saw this question earlier. So when does ICWA apply? Under the new guidelines, A.3.C, the agencies and state courts in every child custody proceeding must ask whether the child is or could be an Indian child and conduct an investigation into whether the child is an Indian child. Now, this changes a focus, if you will. The courts and the agencies really have always had to ask this question. But in this instance, in the guidelines, we're really going to get a standard that says essentially in every child custody proceeding, the question must be asked. Even if you have reason to believe that there is no chance that child is Indian, you still have to ask that question. And the investigation needs to be conducted, which means that there needs to be some sort of finding resulting from the investigation as to whether the child is or is not Indian. So if you see that second bullet there, it says even in those cases in which the child is not removed from the home, such as when an agency opens an investigation or the court orders the family to engage in services to keep the child in the home as part of a diversion, differential, alternative response, or other program, the agencies in the court should follow the verification and notice provision of these guidelines. So as soon as the case is open, if the custody proceeding is open, and even if a removal does not occur, the question of whether the child is Indian and the determination, meaning based upon evidence and investigation as to whether or not that child is Indian, must be performed. And this is probably my favorite. Section A has language in it that says specifically that this section is intended to make clear that there is no existing Indian family exception to the application of the Indian Child Welfare Act. The existing Indian family exception or the doctrine is a judicially created exception to the application of ICWA. And you can see there's a number of decisions that we have had that have come from the state courts in which the judges are really stretching to reach a decision. And a lot of times they base it upon the idea that there is not a tie between the Indian family and the tribal culture, which requires an assessment by the state court and sometimes the social services agencies to actually analyze what an existing Indian family looks like. And because I know that varies across the country, I find it really difficult to believe that there is anybody who lives outside of Indian country who really could make that determination within the scope of all of the issues that tribal cultures have faced. It's very difficult to be able to explain why some tribes have broad land bases and some don't, why some have access to the resources that their culture had originally survived on and why some don't. The reason why some people know which tribe they're from and why some don't. And we still have a number of people who have moved through federal programs of relocation, tribes that have been terminated, it results in people understanding that they have a tribal heritage, but they don't necessarily have a way of proving it, acknowledging it, or even sometimes even knowing what it is. So with that being said, it's probably a smaller segment of our ICWA cases, but it is there, and it has resulted in a number of decisions that have created these exceptions to the ICWA application that have really been detrimental to a number of cases. So that one is, again, my favorite, A.3.B. Okay, what's happening here? There we go. The next one, the next broad statement that comes in the guidelines is that the best interest of the Indian child is presumed to be within the ICWA placement preferences, meaning that any analysis to deviate from those preferences is actually outside of the best interest of the child. So what we're really looking for is for the courts and for the agencies to accept that those placement preferences have been put in place and are in the best interest of children, and that deviation from those placement preferences for any reason has to be documented, and an independent analysis taking into consideration socioeconomic concerns, any other concerns that they can come up with are really going to have to be documented and will be fundamentally inappropriate unless they can be documented and proven. So it's essentially that ICWA on its face is in the best interest of Indian children. Okay, so most of the focus is in Section F, which deals with the placement preferences specifically. And like I said, there's some language in B that deals with definitions and implementation. Now, in general, there's a summary of the sections in the new guidelines at the beginning. And one of the areas of the summary that sort of draws out all the information is on this slide. And it says that the agencies, and we're really looking here at those agencies that are effecting the removals and the placements, the agency bears the burden of proof if it departs from any of the placement preferences and must demonstrate that it conducted a diligent search to identify placement options that satisfy the placement preferences, including notification to the child's parents or Indian custodians, extended family, tribe, and others. And what we're often seeing is tribal advocates, tribal ICWA advocates, oftentimes finding the family of the child who will be willing to take the child in, providing names and numbers, and then oftentimes very suspect that the agencies never tried to contact those families. And the agencies may claim that they did, but there's no documentation as to the scope of the contact. Did they call them once? Did they call and leave a message? Did they send letters? Was the contact ever effective? And so at this point, what we're looking at is that there is a requirement, a must, that they demonstrate that they actually did a diligent search. A diligent search is not going to be a simple call and nobody answers so you don't call again. A diligent search is making sure that communication actually occurs and a response is actually documented. So when we're looking at this, the burden is really going to increase on the agencies. There's no doubt about it, but that burden really is not much different than what the expectation was of their conduct prior to the guidelines. The court determines whether good cause to deviate from the placement preferences exists before departing from the placement preferences. So this is another new burden that the court and the agencies are going to have to bear. So the requirement under the guidelines, and again, we're going to kind of intermingle our language here. So by the end of the year, if this provision survives into the rule, it will be a requirement. For now, it's good practice that before there's a departure from the placement preferences, the court has to make a determination about good cause. So it has to do an analysis. It's going to have to look at the existing placements, compare it to the alternative placement. It's going to have to explain the alternative placement to all the parties. That includes the tribes. And then they're going to have to document the responses to the placement. Now, one of the other major issues that's come about, and this is really in line with the highly publicized cases that we've seen in the media about the placement of children in adoptive settings, and that is that good cause does not include normal bonding or attachment that may have resulted from a placement that failed to comply with the act. So if a child ends up in the care of an adoptive family and the court is going through its processes, the longer the time the child spends in the adoptive care, everybody has a tendency to believe that that's probably the best place for that child to stay because of the bonding or the attachment that has occurred. This statement basically says that's no longer a basis for good cause to deviate from the placement preferences, that we will deal with the breaking of the bonding and the attachment before we actually submit to the idea that it's going to determine the placement. And then finally here, because ICWA does not allow for consideration of socioeconomic status in the placement preferences, this section, Section F, also clarifies that the court may not depart from preferences based upon socioeconomic status of one placement relative to another, except in extreme circumstances. There's not much in the new guidelines with respect to what those extreme circumstances may be, but if it is basic care, that's probably where we're going to fall with that. My guess is that's going to be open to clarification by the agencies and the courts when they do their investigations. Okay. Now, I won't hit upon this anymore. This is just to make sure that everybody understands that the placement preferences apply, they're mandatory, and the only deviation on the face of those preferences is if the tribe has established a different order by resolution and have incorporated it into their own rules. So just keep in mind, placement preferences are kind of the law of the land unless the tribe is set forth a different set of preferences. Okay, now, one of the changes that we're seeing, and this comes from reading through Section F1B in particular, that we just looked at that idea that the agencies are going to have to show that they've done a diligent search to identify all of those placement preferences. But F1B actually establishes an evidentiary standard for that to occur. So when we were looking at, Josie had a question up here earlier. It says, do we know what type of documentation would be required in the new guidelines about placement preferences? Now, this outlines what that will be. So it's not necessarily any particular type of documentation, but documentation that satisfies the evidentiary standard of clear and convincing evidence, number one, that they conducted a diligent search to identify options that satisfy the placement preferences for adoptive, pre-adoptive, and foster care. If there's a deviation from those placement preferences, this clear and convincing evidence standard is going to follow from the performance of a diligent search. So the language in the adoptive placements and placement preferences stays the same. We still have the same concerns about absence of good cause to the contrary, which gets a little more clarification we'll see later. The definition of child's extended family, which can come from the tribe. And we have our placement preferences. And then we have now, if there's going to be a deviation and a follow-through on the investigation, that it meets a clear and convincing evidence standard. Now, when we're talking about evidentiary standards, everybody's familiar with beyond a reasonable doubt. And if we were to throw a percentage at that, people often like to say it's 99.9%. I like to think of it more in terms of scales. If you think of those old-fashioned scales where they weighed things on them, clear and convincing, it's the scale's tipping a little bit closer to 75%. Above that, you have beyond a reasonable doubt. That's when one of those scales comes down all the way to the table. And the lower standard is preponderance of the evidence, which is kind of just past 50%. It's enough to just start to see those scales come out of balance. But clear and convincing is definitely out of balance, definitely heading towards the table, and very much a basis for making a statement that the diligent search was conducted and that they either found or did not find options for the placement preferences. Now, another statement that comes out of Section F is that the court should consider the preference of the Indian child or parent. Now, this was also in the original statute. We showed you that earlier. But in this case, it's reiterated. And it really does talk about the idea that if an Indian parent, and it must be both if they are both available, believes that there is a reason to deviate from the preferences, that they must attest. That means they have to make a legal statement in the court. They have to provide a comment that says, in fact, that they would like to see the preferences changed, or that they would like to see a different placement than what the preferences would actually have occur. And the Indian child must be able to comprehend what it is that they are stating with regards to their placement. So it puts a requirement on the court to actually walk through the steps and make sure that these are also documented and explained well enough to the parents or the child who are asking for a deviation from the placement preferences. Okay, we look at the foster care. Again, the language here has not changed. There is a reiteration of all of the same concerns: least restrictive setting, most approximates a family. The big change that I see here in terms of language, is here in the sentence: the child shall also be placed within reasonable proximity to his or her home, and they've added in here extended family or siblings, taking into account any special needs of the child. This reference here to extended family or siblings is an important one. There's been a lot of work in the last couple of years by children who've been in foster care or in adoptive care, and this is not necessarily tribal youth, who have gained national ground and have had a voice at congressional hearings to talk about the idea that they don't want to be separated from their siblings, and that no matter what their foster care placement was, as long as they were together, they thought they could survive it. And it is getting a lot of attention from people at the congressional level. So this is part of what I know ICWA advocates have been working for a long time, making sure that the connections are there. But those siblings, if more than one child is removed from that home, that they look for settings in which they can remain together or in which they can be in close proximity. And so that's been clarified in the new guidelines. And I won't go back through this. A lot of this is what we have seen before. Okay, so let's talk about this burden of proof for foster care. So what are the applicable standards for evidence? And again, we're back at this issue of a clear and convincing standard. The court may not issue an order effecting a foster care placement of an Indian child unless clear and convincing evidence is presented, including the testimony of one or more qualified expert witnesses demonstrating that the child's continued custody with the child's parents or Indian custodian is likely to result in serious harm to the child. Now, just as a reminder, for termination of parental rights, our evidentiary standard is beyond a reasonable doubt, and it also requires a finding that there's serious emotional or physical damage to the child. But one thing to remember is this conflicts a little bit with the Title IV-E findings that a judge must make in order to have a qualifying out-of-home care stay, an out-of-home care stay that qualifies for Title IV-E reimbursement. And that usually is a requirement that the continued care is likely to result in serious physical or emotional harm. So there's got to be some balance here. And our evidentiary standard says that the court cannot actually issue an order. It can't move ahead unless there's clear and convincing evidence that's presented, includes qualified expert witness testimony, and demonstrates that, in fact, if the child remains in custody of the parent or custodian, it's likely to result in serious harm to the child. So it's going to be to me, what I think is going to be a little bit of a maze for us to follow. A lot of social services, case management, a lot of the out-of-home care stays are reimbursed from Title IV-E, and oftentimes they don't qualify unless there is a finding like this. So there is definitely a weight towards taking children out of the home when this condition is present, if they're likely to result in serious harm or physical injury. But we've seen, and this is in tribal courts as well across the country, that there have been times where those findings were made and there wasn't much to back it up, and it was just to make sure that they were IV-E compliant. So hopefully we have a good eye for that and won't fall into that trap. Okay, so let's talk about good cause. Good cause, like I said, has been one of the most abused loopholes in the Indian Child Welfare Act that we've seen. And it's coming into some defined parameters within the new guidelines. So the old guidelines come from court findings or court rulings about what constitutes good cause. And what we found there, some of the more popular ones, was that good cause existed under the old guidelines if there was a request by the parents or the child, if the child was of sufficient age to deviate from the transfer. This one's to transfer to tribal courts, but good cause exists in the placement preferences as well. If there was extraordinary physical or emotional needs of the child established by testimony of an expert witness, unavailability of suitable homes within the placement preferences, or that the proceeding was at an advanced stage. And what we see in the new guidelines is that they specifically targeted this finding of the proceeding being at an advanced stage and eliminated it as a potential good cause basis, both for deviation from the placement preferences and denial of transfer to tribal court. Under the new guidelines, Section F requires that the court determines whether good cause exists before deviating from the placement preferences. That essentially means conducting that investigation, actually being sure that there is nothing else that can be done. Good cause must be explained and documented. So there's no longer just a statement that's going to come from an agency representative or the judge from the bench that says we have good cause to deny transfer or to deviate from the placement. They actually have to document it. It has to be in the record. The updated criteria is still very general. We have if the parents object, if the child has a say in what's going on, if the tribal court declines to take the case, or if the state court otherwise determines that good cause exists. There's still some room there. But a few things that were eliminated are the advanced stage, and another factor that's no longer to be considered is the level of contacts the child has with the tribe. This factor unnecessarily introduces the outsider's evaluation of the child's relationship with the tribe and cannot sensibly be applied to infants. And so this is another one of those reiterations of what seems to be some of the guiding principles, if you will, under the new guidelines, that these non-tribal evaluations of that tribal child, tribal community, tribal culture dynamic has to be eliminated. Okay, so how is determination for good cause to depart from the placement preferences made? And again, stated on the record or in writing, and must be made available to all of the parties to the proceeding, including the child's tribe, whether or not they've intervened. And then the party seeking departure from the preferences bears the burden of proving by clear and convincing evidence, meeting that standard again, that the existence of good cause to deviate from the placement preferences exists. And so all of these things need to be done before they actually make the alternative placement. And this should actually reduce a number of those abuses of the good cause deviations. Okay, so again, who can do this? We know that the parents can actually make the request for good cause to deviate. Again, they must attest that they've reviewed the placement options. And if a child makes the request, the child has to be at a level of capacity to understand and comprehend the decision that is being made. In both of those instances, the court is going to have to verify that they understood. The court will have to explain the consequences. Number 3, the extraordinary physical or emotional needs of the child, such as specialized treatment that may be unavailable in the community where the families who meet the criteria live. But this has to be established by the qualified expert witness. Now, again, an exclusion for the bonding and attachment issue is reiterated. And number 4, the unavailability of a placement after a showing by the applicable agency and a determination by the court that active efforts have been made to find placements meeting the preference criteria, but none have been located. And this is important. We're starting to move into the active efforts definition, which has gotten a lot of reinvigoration under the new guidelines. And it's going to be employed in the determination of placement preferences. So a lot of the folks who work in this field have always associated active efforts with reunification. The guidelines are moving that bar for reunification from the point of which a lot of people assumed was at the point that the child was going to be removed to the point that the child is actually going to be identified as Indian and as part of a custody proceeding that fits under the ICWA criteria. So we're moving that bar for starting of active efforts back as far as possible. So in this case, it's supporting that at the point that we're looking for any placements, that a determination by the court that active efforts were made for finding placements that meet the criteria, but none have been located. Okay. And finally, Part D, the court should consider only whether a placement in accordance with preferences meets the physical, mental, emotional needs of the child and may not depart from the preferences based upon socioeconomic status of any placement relative to another. That provision gets reiterated several times. And these come from the cases where those loopholes were being met by the socioeconomic findings. Now, in voluntary proceedings, there's not a lot that has changed here other than to reiterate that even in a voluntary proceeding, if an Indian child is involved, there must be determination as to whether ICWA applies. So if there is a finding that this child is in fact an Indian child, then you must walk through the steps, which means that although notice may not be required under ICWA, California has a variation on that, that there still is a right for the tribe to intervene and that there still are consent requirements that ICWA outlines. And those consent requirements get a little bit more of a structure in the new guidelines. So they still need to be in writing, still must be recorded before a court of competent jurisdiction. On the left-hand side are the requirements as they stand now. The judge must certify that the terms and consequences of consent were fully explained. So that includes conditions, timings, and withdrawal. And the judge must certify that the consenting adult understood the language or had an interpreter in which it was all explained. And then the final, a consent given prior to or within 10 days after birth of the Indian child is not valid. And we have seen even that provision circumvented when there has been a long-term attachment or bond with the adoptive care or adoptive family. Under the new guidelines, there's a reiteration that you must walk through the steps of the applicable ICWA provisions. You still must get the consent in writing. The consent must document or identify any conditions to the consent and requires the court to explain the consequences of the consent before its execution. So if, for example, somebody is putting a child up for adoption because they don't have the resources they need, they're not married, or they don't have a home, those kinds of conditions must be identified as a basis for putting the child up for adoption. And if, in fact, there is a chance for those conditions to change, that the consequences of giving the consent to the voluntary proceeding must be explained, the idea that it can be withdrawn in a certain time frame and before the final consent decree is on record. Now, it also addresses steps for the withdrawal, and it restates the statutory restriction on the 10 days. So a lot of it's the same, but it has a little bit more emphasis on the 10 days and the certification by the judge. The certification now is expanded a little bit to include the documentation of the consequences. Okay. And these remain the same. Again, consent can be withdrawn at any time before the entry of the final decree of adoption, and after the final decree is entered, it still may be withdrawn, but only on the basis that the consent was obtained through fraud or duress. And this has not changed the invalidation of a state court proceeding. If there are provisions, and they are specific provisions of ICWA that, if violated, led to the voluntary placement, then they still can be overturned in state court or invalidated in state court. The standing to do so lies with the child, the parents, the custodian, or the tribe. Okay, let's get to active efforts, because this one becomes a little bit more enhanced in my opinion. It stretches, like I said, back to the time that we identify the child as Indian and subject to an ICWA proceeding. So what we see in 1912D and the determination of active efforts and where it's required, it falls under 1912D, Remedial Services and Rehabilitative Programs. Says any party seeking to effect a foster care placement of or termination of parental rights to an Indian child under state law shall satisfy the court that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family, and that these efforts have proved unsuccessful. The new guidelines are looking to begin active efforts at a point that they learn the child may be Indian, not the determination that the child is Indian. The application of active efforts requirement actually is throughout the process of investigating and getting the determinations back from the tribe as to whether or not the child is Indian or eligible for membership. So the updated Section B, and that's where you'll find it, New Guidelines Section B, clarifies that active efforts begin from the moment the possibility arises that the Indian child may be removed. And that begins the question of whether or not you have an Indian child who's subject to an ICWA proceeding. The updated section clarifies that active efforts should be conducted while verifying whether the child is an Indian child. And the basis for it says that this clarification ensures compliance with ICWA in cases in which the status of whether the child is an Indian child is not verified until later in the proceeding. So the findings that we had so many families that were not getting any efforts at rehabilitation or reunification until the determination was made, and if it was made later in the proceeding, made it more difficult to meet all the timelines and deadlines that the court has in place, and basically losing children in those placements. So this will hopefully dial it back to the earliest possible moment. And I don't doubt that this is going to be a burden on the courts and social services So one of the things that the tribes can do to actually help create a little bit more success in terms of carrying out this burden for the courts and social services is to identify all of those programs that the tribes have seen as effective or that the tribes are actually administering that the child or the families may be able to participate in. Let's provide as much in the way of resources and identification of services as possible. Now, I have personally been involved in identification of services for certain types of concerns, particularly in victims' issues, and we find a number of agencies who claim that they provide a certain service, but it may in fact have ended because of funding running out. So it's always a good idea to have this as kind of an annual database, if you will, within your own community. Look at these programs. Are they currently in place? Are they working? Which is, it may be a subjective analysis, but it's going to be important, in fact, that you make that determination. Okay, under the new guidelines, when does the requirement for active efforts begin? This is under B1A. Begins from the moment that the possibility arises that an agency case or investigation may result in the need for the Indian child to be placed outside the custody of either parent or Indian custodian in order to prevent removal. So this is the language that we're looking at as a guideline, potentially in the final rule. Active efforts to prevent removal of the child must be conducted while investigating whether the child is a member of the tribe, is eligible for membership in the tribe, or whether a biological parent of the child is or is not a member of the tribe. So ultimately, these are guidelines now, potential requirements later. Okay. Now, we haven't had much change here, but there's definitely some clarification. So the agencies must ask whether there's a reason to believe a child that is subject to a child custody proceeding is an Indian child. That was always a question for the court to ask. The agencies now are bound to ask at the beginning of their investigations. If there's a reason to believe the child is an Indian child, the agency must obtain verification in writing from all tribes in which it is believed that the child is a member or eligible for membership as to whether the child is in fact an Indian child. And this again is going to increase the burden on the agencies. There are a number of cases in which somebody will come in and say, we believe we're Indian, but we don't know which tribe. That opens it up for a number of tribes in a region, a number of tribes and sometimes throughout a state. It can be kind of daunting. So it's going to be important that we have our rules up to date, that we have processes in place to do this as quickly as possible. Then the state courts are responsible for asking the threshold question at the start of any state court child proceeding, whether there is reason to believe the child who is the subject of the proceeding is an Indian child by asking each party to the case, including guardian ad litem, agency representative, to certify on the record whether they have discovered or know of any information that suggests or indicates the child is an Indian child. Now, this burden raises the bar, particularly upon agency representatives who are really going to have to go on record and make those statements. And if they don't make a truthful statement, it's going to be deemed perjury. So courts may require the agencies to provide evidence of this certification. So not only do they have to certify on the record, but the court may ask to provide the evidence of the finding that led them to that result. Now, this will bring in a lot more evidence to the record and probably help the ICWA advocates quite a bit. A lot of this information before didn't have any substantial evidence to back it up. Okay, B2. If there's a reason to believe the child is an Indian child, the court must confirm that the agency used active efforts to work with all tribes of which the child may be a member to verify whether the child is in fact a member or eligible for membership in any tribe under the paragraph. So just keep an eye on the idea that active efforts now is applicable to even the confirmation of whether a tribe is an Indian or eligible for membership in any tribe. So no longer able to resolve that question by making phone calls and not receiving responses. There's going to have to be a higher level of standard here. One thing that hasn't changed from the point of receiving notice for foster care or termination of parental rights, we still have the same waiting periods. And these are all essentially the same, with the furthest one being 30 days out. There is some language in the new guidelines that basically say that membership determinations are strictly up to the tribe. that waiting for the secretary to respond is probably not the best bet. So, hopefully those will not really affect any of the proceedings, but the tribes, again, are going to have to fill in there for the lack of response from the secretary. We're going to have to need to be more interactive in making sure that we get the notices and respond as soon as possible. Okay, where we are on time here. Okay. Now for emergency removals and placements, this again, we need to look at the language that comes along with an emergency removal. It's often the same language for the Title 4E reimbursements, and that is that emergency removals and emergency placements should be severely limited, applying only in circumstances involving imminent physical damage or harm. This language is very specifically associated with the 4E compliant judicial orders. So if a case involves removal of a child, even for a short time period, once that out-of-home placement starts, in order for it to be eligible for 4E reimbursement, there must be a judicial finding that removes the child from the home on this basis. There are a few other bases, but this is usually the one that is the most relied upon. The updated Section B clarifies that the guidelines for emergency removal or placement apply regardless of whether the Indian child is resident or domiciled on a reservation. The section explicitly states the standard for determining whether emergency removal or emergency placement is appropriate, and that's the prevention of imminent physical damage or harm. If there is any other reason whatsoever other than this, it's probably not going to be appropriate to remove the child. And of course, those are going to be subject to judicial interpretation. The guidelines clearly state that the emergency removal and placement must be as short as possible and provide guidance on how to ensure it is as short as possible. And this is where one major change occurs. The new guidelines shorten the time period for temporary custody without a hearing or extraordinary circumstances from 90 days to 30 days. So if we have an emergency removal and it's just deemed to be temporary and no hearing occurs, so this is oftentimes the things that can occur on weekends when there's not an availability of hearing time, or there's extraordinary circumstances. The time frame shortens now to 30 days. And the right to transfer the proceeding to tribal court available at any stage in the proceeding includes during the emergency removal and placement. So it is quite possible for a tribal court to intervene in an emergency placement even without the state court having the hearing. So a lot of that can happen through phone discussions or MOUs or things that may be in place between tribes in the state. Okay, so we've talked a lot about the new guidelines and what they do, and the question is, what about the proposed regulations? Why aren't we talking about those? Well, like I told you, a bulk of what's in the proposed regulations, which will be rules and requirements that will apply, are really taking the language from the guidelines. The only variation that we have there are the definitions. There are a few new definitions and a few revised definitions that are in the proposed regulations. And I've included them here in the PowerPoint, and I'm just going to show you the version or the format that I have here in the PowerPoint and let you read those on your own. Most of the revisions are technical revisions. They don't have a lot of content except for a few places where there was a paragraph that was added, and it's basically to emphasize the things that we've gone over. So when the new guidelines are integrated into the federal regs as a rule, hopefully at the end of the year, they'll be codified in 25 CFR 23. The new definitions will be included in the ICWA statute at 25 U.S.C. 1901. 1902 is a section for definitions. And what we had are essentially 8 additions in the definition section and 8 revisions in the definition section. And this slide shows you which definitions. So we added the definition for active efforts. We revised for child custody, and so on down this list. So what I did in the slides, so when you download the slides, you'll have some idea of where my mind was. In the addition section, I included most of the language. For active efforts, there's a list of 15 examples, and those examples are probably going to be included in the rules and the regs if it's adopted, but I left those out of here just for brevity. So active efforts means actions intended primarily to maintain and reunite an Indian child with his or her family or tribal community and constitute more than reasonable efforts as required by Title IV-E. And then your example, a list of 15 examples follows. And then in the proposed definition, for this one it's the custody proceeding, I included the original definition and then the proposed revision. In the original where the language has changed, that language is underlined. And in the proposed revised definition, the language that's added is in red. So it'll give you some idea of what the changes are. And you can see here they've replaced the shall mean with is. So some of these are really just language technical types of changes. When we go through, so here's an addition for continued custody, custody and domicile, and then proposed revision, again, technical. Trying to get to the one that had added language is here. So proposed revision for Indian custodian. And this is another area, and it's kind of interesting. It doesn't actually surface earlier with the extended family. But in the proposed revised definition of Indian custodian, they've added the following paragraph. An Indian person may demonstrate that he or she is an Indian custodian by looking to tribal law or tribal custom or state law. So another area in which tribal codes should be adopting a definition of Indian custodian that they can then define, that the tribal code can incorporate and state courts can rely upon. Okay, so I'm not going to go through all the details here. As you can see, there's just a few of the revised where there's substance. The additions are usually the ones that are really going to be the ones you need to look at. And that'll bring us to the end here. And I've left time for questions. I don't know that anybody has any. I don't see any more in the chat, but I will unmute here in a second. So just first of all, I want to thank everybody for their time for participating, and just to let you know that we'll keep our eyes on when the regulations are incorporated into a final rule and make sure that that is all distributed to everybody. And if the time comes, we'll be doing some more updates to show the impacts of the guidelines on some of the existing curricula that we have. And again, if you have any questions at all that we don't get answered on the next section, email me here at nijc@aol.com. That email does go directly to me. I know it looks pretty generic, but I'm the only one with access to the box. So that's it for the official presentation, and I'm going to open up the audio controls, and if you have questions, you can go ahead.
The conference has been muted.
Oops, there we go.
The conference has been unmuted.
So if you have any other questions, you can go by chat, or you can go ahead and ask me. So otherwise, that's it. Go ahead and close it up, and everybody have a good weekend, and I'll hang out on the line in case any questions arise.
Hello?
Hello.
I have a question.
Go ahead.
Okay. I am confused about the section. I'm looking for it, and sorry for, I think I can just phrase it, but there's a section that says the child cannot be placed in foster care unless there is clear and convincing evidence of serious, I can't think of the exact language.
The serious bodily injury or harm?
Right. So the idea is, and the burden of proof is clear and convincing evidence in that particular section for removing the child out of the home into foster care.
So the clear and convincing evidence standard applies when you are going to deviate from the placement preferences. And then when you have an order that's going to remove the child from the home, it has to include that statement in the judicial order that the removal is being done on the basis of, and this is for the emergency removal, on the basis to prevent pending or imminent bodily injury or harm. So they're kind of two separate things. So think about the emergency removal having this very high threshold that if you don't take the child out, it could result in serious bodily injury or harm. But if you are going to affect a foster care or adoptive removal and it doesn't involve that emergency situation, then there must be clear and convincing evidence if you, in fact, are going to deviate from the preferences listed in the Act. Does that make sense?
It makes sense, but how would that apply in the initial, what we have here is a 48-hour probable cause hearing when there's a petition filed and the court holds a probable cause hearing and the child is, the OCS or the social services is asking to remove the child?
So if you're looking at the 48-hour time frame, and I think, I don't know if I can do this without a visual, but a lot of the time frames that the courts are bound to follow and that the agencies are bound to follow come from the Adoption and Safe Families Act and Title IV-E, which follows this timeline of when hearings have to happen and when determinations have to be made. Throughout the guidelines, they actually have a lot of statements with regards to the idea that ICWA cases need to be separate from those ASFA timelines. That's going to be really difficult for state courts and agencies to actually deal with. We really only have a small percentage of cases that involve Indians in their entire caseload. So you can start from the assumption that you can make an argument that says this is an ICWA case, and that's one of the reasons why the new guidelines basically require that the judges and agencies start off with the question as to whether or not it's an Indian child, because that would separate it out from the ASFA and 4E timeline. But it's going to take some practice for the state courts and agencies to get used to that, because that's actually been an issue all along. So if you have those 48-hour time frames, and are you talking about an emergency hearing?
Well, the way it works in Alaska is the department will file a petition and the court tries to hold a hearing within 48 hours, just a regular China, we call it child in need of aid petition. And the standard of proof at that initial hearing after the child is identified as being an Indian child is still at the probable cause level, more likely than not, because it's not a final adjudication. But what happens is, it's a lower level of proof, and then the child ends up in foster care.
Oh, she's not locked in there.
And
So
many times not in a placement, ICWA placement preference.
So they're essentially not applying the ICWA law to the case because the 48 hours time frame is short? I guess the first question I have for you is they're not recognizing the child as being subject to an ICWA proceeding, correct?
They are recognizing that it's a ICWA case.
Okay. Honestly, I think these guidelines are really going to help you then. I think that what's going to have to happen, though, is that you're probably going to have to make the agencies in the state court aware of them and fight for their application. For right now, they're still guidelines. But the guidelines include provisions that would basically require that during the determination that the child is in fact Indian, even though they haven't had a final adjudication, that they still follow the ICWA placement preferences. And that if they deviate from those preferences, that they have to document why, and that their standard of evidence to deviate is that clear and convincing. So it's there. They need to be made aware of it. It's not a requirement, though, until we get the final rule, and we're not expecting that until the end of the year at the earliest.
Okay, that's what I thought I heard you say, but since that's not the actual practice.
Yeah, Alaska's tough. Yeah, there's no doubt about that. And, honestly, there's a lot of support at the federal level from the Alaska delegates, the senators and the representatives for the guidelines. That was surprising for everybody. But I think that if you can basically keep practicing by saying, okay, we have these guidelines. The guidelines, require that you treat this as an ICWA case, and here are the level of evidentiary standards for deviating from the placement preferences, and you don't have to have a determination that the child's Indian before you apply the ICWA case requirements to it. It's just as long as you think they may be Indian or Alaska Native, they fit. We can talk about it further if you like. I honestly think that this may be something for, for the states where it's more difficult for the courts to actually employ ICWA for principles and other issues are concerned. They may end up not doing it until it's required, which would be at the end of the year.
I think probably the problem is that the state laws are not similar. So, but thank you. I appreciate your answer.
Sure.
I have a question.
Go ahead.
In key definitions under Indian child, of course, it has 1 and 2, and 2 has 2 parts.
Right.
Which you brought up. Eligibility for membership in a federally recognized tribe and the biological child of a member. Does that mean, would it be ICWA, the child is not eligible for enrollment because they don't meet the blood quantum, but the parent is an enrolled member?
Still considers them eligible, right? Wow.
No, the child isn't going to meet the eligibility requirement. So the child is not going to be eligible for enrollment.
Their descendant.
Right, but I'm just wondering because it says eligible for enrollment and the biological child. Now the child is a biological child of an enrolled member, but the child is not going to be eligible for enrollment.
And you're telling me it will never be eligible for enrollment?
That's right.
Okay.
At this point, no, this child will never be eligible for enrollment because the parent is at the end of the blood quantum. And that would be maybe if the tribe maybe decided to lower its blood quantum, but that's not something they're even looking at.
So you have a couple of lines of argument there, and this is kind of me putting on a different hat. This is the lawyer's hat. So if it was a case that I was having to present, I would honestly present it from the perspective of that the tribe has a chance to change its eligibility requirements during the first 18 years of this child's life, so that there is a chance for eligibility. But if the judge is focused on what happens, now or in the next 6 months, if that child cannot gain membership at the point that they turn a certain age, you could lose that argument. So, yeah, the honest reading of this is that the child has to be eligible for membership under that criteria and is a biological child of a member. That's the most solid footing that you could have if you're presenting there. But I'll be honest with you, I have used that kind of example in our trainings for a number of years to get tribes to think about just the idea that their eligibility for membership and the criteria for that eligibility needs to be stated in such a way so that it serves all of the children for their community.
Right.
So if you have people who are definitely nearing that blood quantum and their children will never be eligible, the community members need to understand that. They need to understand that ICWA is not going to apply to their kids. And it may be reason for the tribe to consider changing that criteria. And I know that's always a difficult conversation, but most of the time when I talk to tribal leaders and I say, you do realize that your criteria for eligibility excludes a certain number of people from the coverage of the Indian Child Welfare Act, they usually aren't aware of that.
Right.
And once made aware, they can at least consider other reasons for changing the membership criteria.
Right. Even if it doesn't necessarily mean that it's a blood quantum, but a biological child of an enrolled member.
Exactly.
So, yeah, boy, I would love to see that. We would lose less children.
Yeah, and it's important. I really think that everybody needs to understand that I get calls at my office that I oftentimes am referring out to ICWA advocates in our area, and I usually get them the day before a hearing from a family who does not know whether or not their child is subject to ICWA, and they've just heard about the law. And those things, it really shouldn't be happening. We should have a way for Indian people to know and understand if their children, in fact, are eligible for membership or not.
Right.
And, a lot of that can come from problems that we've had in the community about membership and disenrollment. But this is the one place where I say set that all aside, set politics aside, and just decide if you want to make sure that all the children that are tribal members, tribal descendants, children of your tribal members should have the protection of this act.
Yes.
I appreciate your assistance. Thank you.
Uh-huh. Okay, anybody else on the call, if you have questions, go ahead and let me know. And just so that everybody knows, a couple of questions that came up on the chat were whether or not they could get access to the PowerPoint slides. And yes, I have a PDF of the slides that's posted on the website, which is nijc.org/NACTF.html. That was at the beginning of the slides. And I put it up in PDF just so it was easier to download. There's some graphics in there. I've got to figure out if I'm going to be able to email it. I should be able to, but I'll see if I can post it as well in what they call a flattened web version. Hopefully it'll be a little easier to download. Okay, any other questions?
Thank you.
Okay, everybody have a great weekend, and thanks for participating.
Thank you.
Mm-hmm. Bye-bye.
Bye.